Good morning, everybody. Thank you for joining us for this webinar about mediation and the benefits of mediation. I'm asked to remind you that this webinar is going to be recorded. I know you will have been aware of that from the beginning, but it's going to be recorded and the recording will be circulated to all those who've signed up at the end. My name's Anne Studd. I am an advocate, a Silk in 5 Essex Court. I've been involved with mediation since it really first started as a pilot scheme introduced by the civil courts as a free means of sorting out various disputes. It used to be confined to very, very contentious ones, but now, of course, it's broadened across. Alex Ustych, my colleague on this webinar, is an accredited mediator trained to perform in mediations. And so we're going to deal with this issue from both sides of the fence, as it were. Firstly, from the side of the mediator and what the mediator seeks to achieve and how they do it. And then from the side of the advocate as to how you can best manage the successful mediation. So I'm going to start by turning to Alex, who's going to deal with the overview.
Thanks, Anne. I look forward to lifting the veil somewhat on the mediator side of mediations. I trained as a mediator back during the lockdowns when perhaps I had more free time than usual. And it was an incredibly enlightening experience, which allowed me to see mediations, having been participating in them as an advocate previously from a different perspective. So I'm going to try and share some of that. So briefly, I'm going to set out the basics of what mediation is. I appreciate many of you will be familiar with this, but just to tick that box as well. It is a form of mutually assisted negotiation. So it's held with the facilitation of a third-party mediator within a structured process. And the structure of that is there for good reasons based on research as to what works and doesn't. It's in a formal setting during a defined period of time. And all of those factors are intended to create an impetus for settlement on the day. The third-party mediator does not play the role of a judge or give an evaluation of the merits, but it is part of our role to realism test parties' positions and ask robust questions sometimes. The role is primarily to accommodate the parties in reaching a settlement, make sure they feel heard and their perspectives are understood and conveyed. The parties, with the assistance of the mediator, can reach an agreed solution, which is then tailored to their real needs and interests. So it goes slightly beyond, ideally, the strict determination of liability that you would see in a court setting. It goes to motivations to a greater extent. Mediation in the UK has a success rate of over 80%. So 4 out of 5 cases involved in formal mediation settle either at the mediation or shortly after. We propose to give you something of a nose-to-tail guide to mediation in a practical way. And you can see the areas we're going to cover on the slide. So everything from preparation, consideration of whether mediation is appropriate, through to the actual mediation, formalizing the settlement. And we will particularly, based on our expertise, look at mediations dealing with data, information, and privacy, insofar as they may be slightly different. So the next question, the first question perhaps to ask is mediation right for your case? And of course, you would need to consider how is it an added value above trial, Part 36, or joint settlement meetings. So dealing with the trial aspect first, it takes at the moment something like 1.5 years for a more complex case in England and Wales to reach trial. Mediation is, of course, far quicker. It can be done even before the case is issued, so pre-action, so you're saving you those considerable issue fees for higher-end matters. And unlike a CPR, civil procedure rules-bound process, mediation is flexible and can be tailored to meet the needs of each case and things like vulnerabilities and specific needs of the individuals. Mediations can take place under a structured process, and it's all geared toward gradually moving parties away from their entrenched position, which you see in litigation, and arriving at a practical solution. It is also, very importantly, as Anne will explain in due course, a private and confidential process. And that can be very valuable, particularly in the data cyber cases we deal with, where organization is keen not to wave a flag at trial or at a hearing even, to attract many more claimants to emerge out of the woodwork to pursue a claim following a breach. It also avoids the stress and trauma that comes from litigation, especially for vulnerable claimants giving evidence. And sometimes, of course, defendants' witnesses can also struggle in that respect. In data and privacy cases involving sensitive information, it can be very difficult to give evidence about what happened and be cross-examined. Of course, in privacy cases, you can apply for anonymity, but it still feels like a very exposing process to be in one of those traditional wood-paneled large courts at the Royal Courts of Justice talking about what's gone on. A settlement can be reached by mutual agreement and allows parties to preserve their pre-existing relationships. And that can be important both in a business relationship and in a relationship between a public authority and an individual, where a form of trust and confidence is important. And lastly, mediation enables the parties to be more creative because you're not limited just to those remedies which are available through the court. And we'll tell you a good example about one such case later on. So what about the added value over a JSM or just Part 36 correspondence? Well, it's a greater opportunity in mediation for parties to communicate their views in a non-adversarial context through the filter of the mediator without it descending into a confrontational process or an examination of the merits like a quasi-trial, which does unfortunately happen at JSMs quite a lot. Mediation can also allow the person, or particularly the claimant, to feel heard, which can often be as important as compensation, something that we as mediators are taught about. It's not just the money, there's a psychological dimension to it. And that's just not the case without prejudice correspondence, which is really drafted to be seen by a court in due course. And studies reveal that informal mediation, so like JSM and other approaches, that lack those structured elements of mediation, which I'll talk you through in a little bit, have a lower success and satisfaction rates. This is based on some research from America. So over to you, Anne, to talk you through a few more points on this.
Yes, so far as mediation is concerned, it's really, really valuable where you've got issues of reputational damage, because it's a confidential process. You can reach an agreement behind closed doors, if you like, and it need never see the light of day. You can have mediation proceedings before proceedings are even issued. So that means no public court documents, no ability for the press to inspect any documents which have been filed. So it's useful then. It's also very useful if you have got tricky opponents where you are trying very hard not to have a marked deterioration in your relationship, because you know that that's what's going to cause a difficulty trying to resolve the issues between the parties. So having that third party neutral person in the middle can be very, very, very helpful where you have tricky opponents. The other time when it is really useful is when it's very hard to evaluate the claim, and that can be quite common in information cases, because quite a lot of the value of the claim comes about as a result of the impact it's had on a particular claimant. And it's hard to really gauge that until you actually know what they're trying to say. So the advantage there of a mediation, even if you don't get a final agreement, is that you will have been able to evaluate their claim much more clearly. You can also explore remedies that are not available in a normal court process. And that can be anything from an apology to something a bit more creative, which we'll come on to a bit later, but trying to get participation from a claimant in training, for example, something like that. And lastly, and this really mirrors what I said a little bit earlier, is you get to see the claimants or the defendants. So you can actually see them before you end up in a courtroom and make an evaluation of how they're going to be in a court and what you think a judge is going to make of them. And that can be of great assistance. You'll all remember trials where you go to trial and the claimant gets in the witness box and you wish you weren't at trial. Well, mediation can absolutely avoid that situation.
Thanks, Anne. Well, we can't say that mediation is absolutely worth the extra cost in every single case. And so we discussed, well, what kind of case might arise where mediation cost may not be worth it. Well, but there's not many areas where this is the case, but where there's already been a series of offers, then there's clearly a vast gap between positions. And you can see that's just not been narrowing. Usually this is where one party, hopefully not your client, may have vastly misjudged the value of the case, and the parties already have a clear idea of each other's claims. Now, to give you an example from my practice, dealing with one claim where claimant is insistent her claim is worth £400,000. This has no basis in any guidance or case law. We say it's only worth 20% of that amount, if that, and it's quite difficult, although probably not impossible, to narrow that gap even at a mediation. And in that scenario, it may be more effective. Mediation probably still will be more effective in narrowing the gap than a JSM. But if it's not able to bridge that gap, you might need to then instead consider making a more cost-effective Part 36 offer at the top end of what you think the claim is worth, still discharging your ADR duty and hopefully setting up cost protection. But what is that extra for mediation over other forms of ADR that I mentioned? Well, assuming the parties' costs of preparing for and attending a JSM are roughly the same as in mediation, the extra cost is primarily the mediator fee. For a full day mediation, mid-range mediators may charge £2,000 to £4,000. Specialists may be 5 to 7 or so, more for commercial litigation. That's not really our area. There might be some venue costs as well if sufficient number of rooms can't be found at one of the parties' premises. The Civil Mediation Council, CMC, also has a fixed fee scheme for disputes up to £50,000, which provides for shorter mediation, usually 3 hours, but at much, much cheaper cost as well. So the cost is not a huge barrier in the context of the types of values of cases we tend to deal with. So next, we're going to look at prerequisite for an effective mediation. Perhaps, obviously, the first one is finding a mediator that everyone ideally can be happy with and is good. So it's essential to find a trained and qualified mediator rather than just someone you know who's a good advocate, because the skill set is very different. Also, qualified mediators are bound by the European Code of Conduct for Mediators, and this has guarantees essential things like independence and confidentiality. The CMC that I mentioned earlier, which is the main regulatory body for civil and commercial mediators, has a find a mediator tool where you can search by area, dispute type, and cost. And the Chartered Institute of Arbitrator has a directory of qualified mediators, so does the Bar Council for barrister mediators. But more often than not, in our experience, you hear about people through word of mouth or recommendations. Well, I've had this good mediator and I'd recommend him or her. So that's often the best way to check in any event. And what about neutrality in mediators?
I think you have to be really careful. So generally speaking, mediators are agreed between the parties. People put forward names, usually because they've heard of them by word of mouth, and you come to an agreement. Sometimes when you've got a really tricky, it's always with the tricky cases, isn't it? When you've got a really tricky case, the other side know that you want to go to mediation, and so they will propose an individual or an individuals, neither of whom you're particularly keen on. But there is a resistance for them to accept going to mediation unless they have one of their choices. The one thing I would say about that is make absolutely sure that whoever it is has been properly trained, because just because they are a well-known face, and it does happen, doesn't mean that they're going to be a successful mediator. And frankly, it's not worth paying the money just to try and get it mediated unless you've got somebody who knows what they're doing. And I'll give you a very good example of that without naming any names. I was involved in a mediation where the mediator was a well-known person who wasn't trained. We did end up mediating it, in fact, but that was largely because the advocates worked very hard at it. The mediator spent most of his time on the telephone to a broadcasting organisation, giving an interview in relation to a completely different issue on a completely different case. And that individual as a mediator was a complete disaster. And I learned a very strong lesson, which was just training is essential. Because then, if you find that it's becoming very difficult, you can actually say to the mediator, you're not acting in accordance with your training, and you can push it back to them. And that will be really helpful in a case where you're concerned about neutrality.
Thanks. And do you think it's important for the mediator to be a specialist in the area of the case?
No, I don't. So far, it depends what you're mediating. I think that if you're mediating something where you think you have a really good argument on the law, which will reduce your liability very considerably or even extinguish it, and so in effect you're looking for more of a nuisance payment and an apology or something along that level, then I think it is worthwhile having somebody who knows at least a bit about the area of law you're arguing about. But mostly in mediations, it's about a different skill set. It's about bringing people together who at the beginning are miles apart. It's about emotional intelligence. It's about seeing cases for what they are, but not getting too stuck in the weeds of the legal argument, because that's a matter for court and it's not necessarily a matter for mediation. So I think it's horses for courses, as with all of these things, but in a large majority of cases, you do not have to have a specialist involved in your case as a mediator.
I agree with that. It's certainly not essential. I think that an area where in data protection might be an example where a mediator who has expertise in the area might be a value add, because as I mentioned earlier, one of our roles is being a reality tester. And the case I mentioned where the parties are so far apart, if I were, say, mediating that case, I would be able to, without, of course, giving a quantum assessment, ask probing questions to just like, what is the basis? What do you cite? How do you work this out? And show, perhaps move parties on from an entrenched position with a bit more professional authority in that area. But by and large, that's not going to be an issue. And that's why we have position statements, and the mediator will be able to read up enough in most cases to muck in properly without being a specialist. On the issue of mucking in, so we do think, so I do think that mediators must not just relay points between the parties' room. We are not sort of a postman between competing parties. It's essential part of our training that incorporates psychology, and I'll try to explain how that works later on, to firstly make sure that it doesn't descend into an adversarial process, which is what happens when you start passing messages about why someone's case is the best one. But secondly, understand the parties and work with them and their individual approaches, and EQ in particular, as Anne mentioned, and psychology of conflict resolution to try and move them through those entrenched position. Otherwise, of course, what's the point of mediation? You could have just kept exchanging aggressive Part 36 letters. So one approach might be, as an example of mucking in, to tell the other party, having heard the first party's argument, well, I completely see your argument, but I can see that the claimant or the defendant doesn't see it that way and won't see it. So let's just move on from that point to deal with the next stage, rather than and everyone ending up stuck on a particular issue in dispute. So on a slightly drier topic, the issue of mediation agreement, I'll breeze through this quite quickly, but it is essential that the mediator and the parties are covered by a robust mediation agreement, because mediations are not regulated by a statutory framework. So it's effectively what you set down in your contract prior to having the mediation happen. So one essential aspect of that is ensuring parties who turn up at the mediation are required by the mediation contracts to have authority to make the process meaningful. Otherwise, it's just a waste of time and money for everyone. Some of the other key clauses included a scope of the mediation. So what are the terms of the dispute, and what's the scope of what we're looking at that particular mediation? Sometimes parties will wish to mediate certain issues, but not others, although of course it's ideal to draw a line under the whole thing. Sometimes it's important to reinforce confidentiality and the without prejudice nature of communications. And there is often a useful clause that says that parties will not attempt to call the mediator as a witness in later legal proceedings. Any settlement reached at the mediation will also not be binding until it's in writing and signed by all the parties. So that's what I would expect the mediation agreement to broadly hit, and ensures everyone's on the same page. I mentioned settlement authority, and do you have any
Yes.
views on how to approach that?
Yes. The one thing I would say, which is slightly different in a mediation, is that you absolutely have to maintain the confidence of the mediator. It's really important, and they have to trust you as one of the parties to the mediations to be doing your very best to try and mediate this successfully. It doesn't always work, but if you lose the confidence of the mediator before lunch, you will lose your chance of getting an agreement that day, or you'll lose a substantial chance of the chance. So, so far as settlement negotiations are concerned and authority is concerned, there's two things really. One, you must have authority for a realistic amount of money, because actually whatever else you can offer, at the end of the day, this is about probably about a financial settlement of some sort. And two, you have to be able, as an advocate or as a lawyer, you have to be able to say what the limits of your authority are. Now, your authority can be different to what the client thinks they will say. So if your authority is for 100,000, it doesn't matter if the client thinks that it might go for a little bit more and might have authority to give you authority for a little bit more. But you need to be very clear about what you can say to the mediator. So please, one of the things I would say, don't say you've got no more authority and then go up to £50,000. If you're going to the top of your bracket, you say you've reached the top of your bracket and keep it as yours. And then that gives you the option of going back to the client and saying, listen, where do we go from here? But keeping the mediator on side and confident in the fact that you are being straight is really, really important, particularly when they come in and ask you a very direct question. You have to be able to answer it in a very direct way.
Thanks, Anne. I think that's a really good practical point and a source of a lot of confusion and different practice in mediations. Before we move on to looking at preparation, disclosure bundles and position statements, just a reminder that you can pop your questions, if you have any, into the Q&A box, and we'll try to deal with them at the end. So position statements and disclosure. So in terms of getting the mediator up to speed, usually there should be a disclosure bundle provided at the same time as the mediation agreement is signed. It doesn't need to be granular. Remember, the mediator is not solving a factual dispute. To limit the number of documents, the mediator can sometimes impose a page limit, but things you might see in that bundle is pleadings, medical report, statement from the claimant, and the main protagonist, defendant, witness. And remember, you can't use documents from created for the mediation at trial, such as the position statement. Documents to the mediator which will enable him or her to identify the issues in the case or to support or test the positions in the position statement is really important to get the maximum value out of your money as far as the mediation is concerned. And as a matter of practice, we are taught that it's often useful to reach out to both parties, either individually or as a break the ice call together, to make sure everyone's on the same page and understands what a mediation is and so on. This is not the same, of course, as getting into the nitty-gritty of things, and there should be no perception of back channeling of any sort. And on the issue of position statements, do you think they're always necessary / useful?
Well, they're not always prescribed for in the mediation agreement. But I haven't yet done a mediation where, well, certainly not in recent times, where there hasn't been one. They can vary from 4 lines to 14 pages, unless they're prescribed. There's a prescribed limit. But the most important thing about the position statement is the tone, because it's the tone of your position statement exchanged in advance of the mediation that is going to be the starting point for the mediation meeting. And if you are going in a very aggressive tone, then the starting point will be very defensive between you and the other side. And it will take a mediator a very, very long time to get everybody to climb down off their horses and start the business of mediation. So in my view, you should be really careful about the tone. That doesn't mean that if you haven't got a very good legal point, you shouldn't outline it, but you should outline it in a way that is not the same as you would if you were in a courtroom, because it's that approach, that position statement approach, that is going to form the basis of the beginning of the mediation. And if you really want to mediate this case effectively, which you probably do if you're in this position, then look very carefully at what you say, but most importantly, how you say it in your position statement.
Yeah, I completely agree with all that. And remember that the position statement is about resolving the conflict, not setting it up or escalating it. As a mediator, I can control a lot of the tone and content of what goes between the two private rooms once we separate out and start this to the sort of the meat of the mediation, but we cannot control what you put in your position statement. So you could potentially really lessen your chances of reaching settlement by aggravating the other side before the mediation ever started. So please don't do that. Let's now look at some of the practicalities and practice at mediation. So perhaps very basic, but what logistics and facilities do you need? So you need a room for each party and a room for a plenary session / for the mediator to be in if he or she is in between sessions with the parties. Lavatories, please. Coffee and lunch. You can maximize the mediation time if everyone's not popping out. Mediator will usually sit at the head of the table during the opening session to show neutrality. Parties and lawyers sit next to each other on the sides of the table. What about timing, Anne? How much time do you think an effective mediation needs?
Well, it rather depends on the case, doesn't it? I mean, you'll probably be aware that the Hillsborough case is all mediated over very many days and over a long period of time, because there were lots of claimants and there were lots of different brackets of people claiming different amounts of money. But generally speaking, where you've got one party or one class of claimants, one set of lawyers and a dependent set of lawyers, I mean, for my part, I've always found that a day is pretty good. I mean, what happens is you start quite early in the morning. There's quite a lot of discussion between the mediator and the parties in the morning. And it's not until after lunch that people actually get down to the nitty-gritty of trying to mediate the case. And a cut-off point is really helpful because it means that there is a certain amount of pressure that's applied to people and it focuses the minds on how they're going to resolve the issues. You know, the cut-off point can always be extended to draft up a mediation, an agreement, the consent, but you really do need a cut-off time to try and make everybody focus. So I tend to think that a day is the sort of routine amount. I think less than a day is quite difficult to achieve much, and more than a day in a standard case leaves it a bit too open from my point of view.
I agree. I think the 3-hour slots under this fixed fee scheme from the dispute CMC are a bit ambitious, especially for the sort of the thornier cases we deal with, perhaps a straightforward contractual dispute. But what about the mediator's role? So what we are taught, we're given a sort of a week of training, which is extremely both theory and hands-on. So a number of scenarios we have to go through, and that's just the start of your practice, because you have to then do practice mediations and so on in your assess. But how does that compare to the reality of what happens in practice? Well, probably the biggest difference as part of the training is you should not give any evaluation of the merits of either party's case. But on the other hand, you should be testing the parties' positions by asking sometimes difficult but important questions to guide them towards a more reconciliatory position. But where's the line between those two principles? Now, that is a matter of judgment in a particular mediation, and probably why you need a mediator with good judgment. In reality, rather than this platonic ideal of a mediation, the mediator may need to ask some pretty robust questions to really probe a party's unrealistic valuation of their case. And that goes back to the point I made earlier about some cases where a mediator's background in that area might be useful. It's not about undermining their case, but it's more about slightly prodding and poking than justified bubble of certainty that they will absolutely triumph and get millions if that doesn't reflect the risks of litigation or the contrary arguments. This has, of course, to be done ultimately within the ethical bounds of the mediation agreement and the mediation agreement. But sometimes you do have to be a bit more robust to move things on, especially when there's an impasse, which we'll deal with in a minute. So what about the different phases of a mediation? As I mentioned, often or pretty much inevitably, in terms of offers, things don't really happen until after lunch. And there's a really good reason for this, in that in our training, we sort of strongly discourage from conveying offers from the outset. There's a particular structure you have to follow, not because it's arbitrary or to prolong things, but because it tends to overcome the initial aggression and, or in some cases, and really sticking to parties' positions. So I'll try to explain how it works. So first of all, opening statement. So that's the plenary or joint session. Mediator will make introductions, confirm each party has an authority to settle, explain the process, emphasize confidentiality and without prejudice, nature of it, explain his or her role, not a judge, but a facilitator. The parties then often make a opening statement based on their position statement, 10 minutes or approximately or so per party, setting out the case from their point of view, their position on the issues, and what they hope to achieve by the end of the process. Claimant typically makes the first opening, but this is counterbalanced by the mediator then going into private session for the first time with a defendant. Generally, there is then 2 private exploratory sessions for each party before turning to the actual offer. So the first is information gathering and scrutiny. So understanding the case from their perspective, hopefully you're most of the way there through the position statements if they're good. But you need to ask yourself, what is really driving the conflict? Legal and factual issues may just be the tip of the iceberg. And then because it's confidential, parties saying anything to you in the mediation, in your private room, can be assured it's not going to be carried across unless they specifically authorize you to, which they may do for tactical reasons. And you have to be very clear about the scope of that. The second private session is then what we call disruption, or WATNA, which is worst alternative to negotiated settlement. So you would discuss how the dispute affects the party's life, their business, consider the impact of settlement not being reached. That's the worst alternative. It might be adverse publicity, damage to relationships, costs, and so on. You would then reality check any entrenched positions, as we discussed earlier. And you would look ahead. So having been through the negative dimension, you look at the positive. What can you do? How will your life move on if you end this dispute? What would the benefits be? If you're a CEO of a company being sued, perhaps you have more time, more money, less difficult issues with your shareholders reporting back constantly on the dispute. If you're a person, less stress, might be able to get some money and go on holiday. You'd be surprised by how effective that last practical thing can be. So together, those 2 factors will drive the parties toward the correct mindset to successfully engage. And that's why you don't go straight into the offers. You have to build that in first. You then go into, and this is typically after lunch, negotiation and private meetings aimed at offers. The mediator will then go to each side, helping them explore a possibility of settlement by formulating offers to convey to the other side with their authority and noting carefully down what's being offered. These continue back and forth until settlement is reached, and usually, as it tends to be just before the cutoff point, but sometimes you do hit an impasse, which we'll discuss next. And the mediator has to encourage creative problem solving, not just thinking about money, but you also have to reality test to make sure the offers are realistic and attractive. Because sometimes parties will say things which are just ridiculous to try and settle the case, and it's not going to do anyone any good if it's not attainable. So what the most difficult really issue in a mediation, and probably why you have a mediator, is sometimes you might have hit an impasse. Well, and from your perspective as an advocate, how do we deal with this?
Well, I think that inevitably happens at some point in the day, I think. And the way really that you can try and deal with it is to try and look outside the area where the impasse is. So let's say you've got an impasse about money. You can encourage with the mediator, you can try and look outside that and see whether or not there's any way that you can offer, for example, a public apology, or in one of the cases that I did, we encouraged a very, very articulate claimant to come and assist with some training arising from the treatment that he had complained about, in fact, at the hands of the police. And he assisted by making a video, which was then played for new recruits in police training for some time. So that was a way of him feeling that he could put something back in, which meant in the end that we were able to agree the financial settlement because, of course, the individual's demeanour was completely different, distracted from worrying about how much money he wasn't being paid, into something much more positive about how he could contribute. So it does help to look at other remedies, go down other paths, but that's one of the key functions of the mediator, to try and help move the parties down other paths. As I said to you before, it's really important that you are able to have a frank, open and honest discussion with the mediator, because there will be areas where you're not going to be able to help for very good reasons, even though it's a suggestion put forward to help with a different type of remedy. And if you can be open and honest about that, and you have the confidence of the mediator, then that's going to help them take that back to the other party with a realistic argument about why that particular path cannot be pursued. So this is what I meant earlier about just trying to develop that relationship of confidence with the mediator so they trust you, because it will really help them to help you. And that's not to be underestimated in any way.
Thanks, and I agree with all that. And there's an aspect as well where sometimes an impasse is reached not because of anything rational around quantum, but just because the parties really hate each other, to put it bluntly. And in those cases, it might be helpful just to highlight the practical thing that if they reach settlement today, they never have to see each other again. They don't have to go to court or live through this for much longer. They can move on. It's also worth reminding the parties as a mediator as to the progress made so far. So any areas of agreement reached, build on them to say, well, we can agree on things. Sometimes even putting in writing agreements which have been reached to reaffirm that it is a constructive process and we got somewhere. Sometimes venting their emotions at you as the mediator can help them move on and past the impasse. Silence can sometimes, or inactivity can actually be helpful, probably not just before 6 o'clock. But a bit of give and take and letting them process can help. Sometimes parties can be asked if they're willing, based on the information they reveal to you, to share some of that with the other party. So, for example, asking a vulnerable claimant about, can I share this bit of impact it's had on you with the other side so they can understand your vantage point a bit more. And just taking a break sometimes. Everyone can have 15 minutes to just think about where they are and come back to it with a bit of a fresh perspective. But yeah, mediation is all about getting past impasses, because otherwise you would just do part 36 if it was easy. Now, if we have an agreement or a lack of agreement, how do we get things finalized, or how do we move on from here? And what do you think?
I think it's really important to get as much agreed as you possibly can in writing on the day, particularly if you're getting very close to agreeing on everything. The worst thing you can do is spend all of the time trying to agree it in principle. They will say, we agree in principle, and then without the pressure of the mediation process, actually the following day they want to change everything. So be really careful about that and get as much formalized in writing. If there are wrinkles that need to be ironed out, put that into the agreement. Very often you get a tax implication or something like that. Put that in the agreement, that's going to be the subject of further discussion, but get what you can written down. I can see in the chat that somebody's asking about costs. When I do it, I make sure that all of the costs are agreed at the point of mediation. So by the time you leave the mediation, you've got a signed agreement that in effect resolves all of the court-related issues, costs included. I think it's really important to try and do that if you can. Then you all know where you are. But as I say, sometimes you do have one or two things that can't be resolved on the day for various practical reasons. That's fine, but make sure that everybody realises that those are the only points upon which further discussion can take place, and everything else is agreed.
Thanks, Anna. We're going to look at next just some specific challenges in information data and privacy mediations. So I deal with a lot of cyber group cases, so following ransomware typically. So the additional challenge there, you have hundreds of thousands of individual claimants, not always represented by the same law firms. And there must be some way to identify the individual features of claimants, if it's in the hundreds or dozens, because that's likely to be relevant to damages. So a concise schedule might help the mediator and to have a bit of more recognition that these people are individuals. You also need clear instructions and authority in place where you have different sets of lawyers and groups of claimants so that there's been some discussion between them so it doesn't get too complicated. But it is not surprising for those types of mediation to span a few days because of complexity. Where there's issues around technical stuff like IT security, processors, whether they did their job, forensic reports, forensic investigation of a cyber attack. Again, you might want to have a mediator then who understands that stuff and have some sort of expert report if produced in the proceedings to be provided to the mediator. In cyber and ransomware cases, it's worth highlighting that both claimants and defendants are victims of cybercrime. That can be a very powerful unifying feature rather than us against them. And for example, often the defendant staff were also affected. Their data might have been stolen as well, and they might be stressed about it. So focus on those commonalities as a mediator or defendant's rep. Focus is, again, likely to be on mitigating reputational harm for the defendant and maintaining customer trust. If you're a big corporate organization, you don't want to lose customers because everyone starts talking about how you've not been able to secure their data. So the confidentiality dimension of mediation here can be very important. And extra care is needed in privacy cases. If it's something like health records or history of criminal allegations, which ends up being exfiltrated or breached or leaked, you need to recognize this is not just a quantification exercise. You can also look at remedies or outcomes which are not available in court but might offer an extra to any financial remedy. So improve data security policy so it doesn't happen again, staff training programs, and more transparent customer notifications. And we were going to look at some pitfalls, tips, and tricks, but I think given the time, and we've actually covered a lot of them in the body, we're going to move on to some of the questions that have been asked. And you've kindly answered one of them. I'm just going to, another question, I see a question we've been asked before the session was what's your most memorable mediation? Maybe I can pick up on that one. So it's mine was where, as an advocate in a mediation of a small commercial dispute, we spent 8 hours in a room together, got very, very close to settlement, but not quite over the line. And having then gone home frustrated, I had a call from my client who ran into his opposite number on the way at Holborn tube station. They went to the Princess Alice pub and they basically bridged that difference. I think they might have annotated the agreement on the back of a tissue or a napkin, not something I would particularly endorse, but probably technically has effect. Let's look, and have any other questions come in?
Yes, sorry. I can just deal with two of them. A question from Jonathan. Position statements are exchanged in advance, usually by the parties, but they can go via the mediator. It depends on what is provided for in the mediation agreement. And Nyan, in relation to funding, I think the question is about an unrepresented individual and funding. I think the best way of dealing with that would be to make a provision that half of the mediation fee should come out of any monies recovered. I don't think that there is any provision for an insurance policy, even under a CFA. So it would just come off as an disbursement. But that would probably be the way to do it. I should say that in most cases where the mediation is successful, the paying party will usually have to agree to pay the mediation costs as well. And probably one of the most interesting ones is, how do you mediate with a Trump type personality? That, Jonathan, is why you have a mediator, because it takes somebody, I'm afraid, who has to speak in a very straightforward way to the Trump type personality. And it is helpful if it's not the person on the other side of the legal fence. So that probably gives the best reason why you should have a mediator. Just by way of wrapping up, thank you very much for attending the webinar. The recording is going to be circulated later this morning. We hope it's provided some helpful pointers. There will also be circulated a feedback form. Please, if you have 2 minutes, could you just complete it? Because it is really, really helpful